Dictation will start in 5 seconds. Start. In the High Court of Punjab and Haryana at Chandigarh, the present petition has been filed by the petitioner seeking issuance of appropriate directions against the respondent authorities. Stop. Learned counsel for the petitioner submits that the impugned order passed by the competent authority is arbitrary, illegal, and contrary to the settled principles of law. Stop. It is further contended that the petitioner has been deprived of his legitimate rights without affording any reasonable opportunity of being heard. Stop. It is also argued that the action of the respondent is discriminatory in nature and violative of constitutional safeguards. Stop. On the other hand, learned counsel appearing on behalf of the respondents has opposed the present petition and submitted that the impugned order has been passed strictly in accordance with law and after due consideration of all relevant facts and circumstances. Stop. It is further submitted that the petitioner has failed to avail the alternative remedy available under the statute and therefore the present petition is not maintainable before this court. Stop. The respondents further submitted that no interference is called for in the present matter. Stop. This court has heard learned counsel for the parties at considerable length and has carefully perused the material available on record. Stop. It is a well settled principle of law that the exercise of an alternative remedy does not bar the jurisdiction of this court under Article 226 of the Constitution of India, especially in cases where the impugned order is passed in violation of the principles of natural justice. Stop. In the present case, it is evident that the petitioner was not afforded an adequate opportunity of hearing before passing of the impugned order. Stop. The record further reveals that certain relevant documents were not taken into consideration by the authority concerned, which has resulted in miscarriage of justice. Stop. The petitioner has also placed reliance upon various judicial pronouncements to substantiate his claim. Stop. In view of the above facts and circumstances, this court is of the considered opinion that the impugned order cannot be sustained in the eyes of law. Stop. Accordingly, the same is hereby set aside and the matter is remanded back to the competent authority for fresh consideration in accordance with law after granting an opportunity of hearing to the petitioner. Stop. The petitioner stands disposed of in the aforesaid terms. Stop. No order as to costs. All pending applications, if any, shall also stand disposed of accordingly. Stop.